Hello, everybody. Welcome to tonight's stream of the Joe Palmetto Law Show. Today, I am going to be talking about the sovereign citizen movement. So it's a question that I've received since doing, since starting up my channel, informing the public about the law. People have, contacted me, sent me some messages to get my opinions on the sovereign citizen movement. I will tell you what my opinion is right now is say what you want about the sovereign citizen movement. Claiming that you're a sovereign citizen when you are in front of the courts, it doesn't work. It's never going to work. And I'm going to explain to you why it does not work. I'm also going to be chatting a little bit with my audience. But if you like this topic, if you like this show, the best way to support it, like, subscribe, comment, and share. Like, subscribe, comment, and share on my YouTube channel, The Joe Palmetto Law Show. So the concept of the sovereign citizen, okay, just to give you a quick rundown of what it is individuals who go before the courts, whether it be a criminal or a civil proceeding, and they claim that they are a sovereign citizen. And the idea behind this is that they are telling the courts, which represent the state or the government of the United States, they're telling the courts that the laws of their government do not apply to these individuals. Okay. And the argument is that these individuals are sovereign individuals or nations in and of their own right. So first, let's take a quick look at the definition of these words. Okay. So the definition of the word sovereign. Now, there are a couple different definitions, but I've pulled up the dictionary. Sovereign. The one that fits the best is one that this is the definition, Merriam-Webster. One that exercises supreme authority within a limited sphere. So a sovereign is one who exercises supreme authority within a limited sphere. That could be an individual, a country. You could apply that to any object. One that exercises supreme authority within a limited sphere. And then the term citizen. Okay, a citizen is a legally recognized subject or national of a state or commonwealth. So when you put those two together, sovereign and citizen, okay, what you are getting here is an individual who sees themselves as the state. They see themselves as the authority, and the argument is that because they are the supreme authority within their sphere, the laws of the government do not apply to them. Okay, so we read into the definition. Sovereign citizen is an individual who exercises supreme authority over themselves. The laws do not apply to them. Now, the sovereign citizen movement, I did a little bit of research on this. It has long historical roots. There is a theory that there was that the founding fathers of the United States set up a system of common law, okay, that at a later point in time, so the founding fathers, late 1700s, okay, early 1800s, set up a system of common law in the United States, and somewhere in that history, all right, that common law was subverted, okay, and taken over by a system of admiralty law, okay, law of the sea and law of international commerce, all right? And the theory goes that this happened either sometime around the Civil War or when the United States moved off the gold standard, all right? To me, that theory, I don't know if there's anything historic to back that up. Hey, John, thanks for joining me. So that's the history of the sovereign citizen movement. Now, I believe that it has been that currently its usage now has been separated from that history a little bit. All right, and it's mostly used by individuals who are being taken into court for one reason or another. All right, and they claim they are their own sovereigns. All right, their own supreme authority. And in a way, they're stating that they are their own country, that they are their own individual country. Okay, now this rarely goes well for the people who come into court and claim that they are a sovereign citizen. And going back deep into constitutional law, some of the original individuals that made arguments like this were the Native Americans. Okay, because think about the scenario. Even prior to the creation of the United States, okay, British, French, European settlers are moving into the Americas. They're setting up their villages. They're migrating westward onto the lands of the Native Americans. The Native Americans had their own nations. They had their own systems. They had their own countries. Okay, but the Europeans who came here, they made there was negotiation, but there was also force. There was negotiation and there was force, and the Europeans came and they took the land here by force, sometimes by negotiation, but mostly by force, given their superior technology, weaponry, etc., etc. Later on, when the United States was fully formed, all right, and had received their independence from Britain. Okay, so we're talking post-Revolutionary War. The country started to expand southward, westward. Okay, the original 13 colonies going west, infringing more and more on Indian states. Okay, but now you have your own fully formed country. All right, under the United States Constitution. And some of these Indian tribes, the Cherokee Indian tribe, who were being told to be removed from lands on the state of Georgia, they brought a case in the United States Supreme Court. They brought a case. The case is, I believe this case is Worcester v. Georgia. Okay. All right. More in this case. All right. In this case, let's see here. Worcester v. Georgia. Georgia criminal statute that prohibited non-native from being present on the opinion which laid out the route and is considered to build the foundation to the doctrine. Okay, this isn't the right case. There was a case, okay, during the era of Andrew Jackson. I believe this was it. All right, so we have Cherokee Nation v. Georgia in 1831. Was a case that the Cherokee Nation brought to essentially remove the United States government's authority over the Cherokee lands in the state of Georgia. All right. And their argument was similar to the sovereign citizen argument. All right. So the Cherokees have lands in Georgia. The United States government comes and overtakes Georgia. The Cherokee still have country within there. And Cherokee argued that the United States government did not have jurisdiction over them, that they were their own country. Okay, and that there was no original jurisdiction of the United States government over the Cherokee Nation. Okay, in Cherokee Nation v. Georgia, 1831 case, United States Supreme Court, Justice John Marshall, who's very famous, wrote an opinion stating that the United States does have jurisdiction over them. They do have jurisdiction over the Indian lands within United States territory. He described this relationship as that between a ward and a guardian, that the United States was the guardian, okay, of the land, all right, that the Indians were bestowed. Therefore, he established that the United States government had jurisdiction over these Indian lands who should have been a sovereign nation. Now, later on, through the development of the law, the federal government began to grant the Indian peoples their own sovereignty. But you have to understand how that formed, right? First, the United States government takes over the lands, establishes sovereignty over these people, and then gives it back to them. So the sovereignty that they now enjoy is still enjoyed to a great degree, okay, at the pleasure of the United States government, all right, at the pleasure of the United States government. So what does that really come down to when we're talking sovereign citizen, when we're talking the sovereignty of other nations or sovereignty of nations within the territory of the United States? What it comes down to, the reason the Supreme Court, the federal United States government, was able to make this decision and enforce it as it was, is because they have the guns, okay? They have the power. And the government, the people with the guns, with the force, okay, for the most part, are the ones who are going to make the rules within that territory. There was, I believe, another Supreme Court case even prior to this where the Indians argued, it may have been this same case, but there was an old Supreme Court case where Native Americans argued the first in time principle, right? Whoever's at the land first, if the land belongs to them. That's actually a long-standing principle in the English common law, which is what our system adopted from, okay? He who finds the land first, it belongs to them. If there's something unclaimed, okay, out there in nature and an individual finds it, he can establish the rights to it first. It's called first in time. There were Indian tribes who made this argument when the United States started to take their territory. They said, hey, in the English common law, you apply this principle first in time. Whoever was there first gets the land. So why don't we, the Native Americans, get the land? We were here first, okay? And essentially, the United States Supreme Court said, it doesn't matter. It doesn't matter. Our laws apply. The case wasn't exactly like that. I got to look that case up. But it was along those lines, similar, if the language wasn't in Cherokee Nation versus Georgia itself, okay, basically stating that the government is going to take jurisdiction because the government can. And once you are within a body that has that type of power and they make the rules, all right, you have to play within that framework, all right? Individuals now who claim sovereign citizenship, right, which is essentially them saying, I never gave consent to the United States government to have jurisdiction over me. When the police come around and arrest them for something, they don't care that they claim sovereign citizenship. When you go before the judge, all right, and you claim sovereign citizenship before the judge, that judge doesn't care, okay? And he doesn't need to care, all right, because there's going to be a bailiff in that room. There's a police force and a whole legal apparatus, okay, that has his back. So when you break it down, the reason that we have to apply the laws of the land, abide by the laws of the land, okay, is because that government has more power than you. It has more power than you. So while there's an argument to be made when it comes to the sovereign citizenship, okay, And I get it, because it's, you're born into this world and you're not necessarily giving your rights over freely or willingly. They're just, you're born with this set of rules and these set of rights that are taken away from you. While I'm sympathetic to it, okay, when you live within the borders of a nation, all right, the nation's not going to buy that argument. They're just not. You know, here's the funny thing about the sovereign citizenship movement, though, because I've seen these individuals who claim sovereign citizenship, and really, to me, what they're attempting to do is they're trying to use the law, use process, use procedure, use technicalities to their advantage. You can do that. You can do that within the established law, within the established rules. That's what I do as a lawyer. Okay, so if you walk into a situation and you claim sovereign citizenship, I'm sympathetic to you. Okay, but it's you could probably do yourself a lot better favor, all right, by reading into the law itself. And I've seen many pro se litigants do fantastic work. And what I would say is, if you really want to make this issue known to the court, if you do a written brief, something like that, throw it in there. Throw in your sovereign citizenship argument. Put it in at the end. The judge may read it. All right, you throw an article in there. A paragraph in there. They may read it. You can even bring it up to the judge. Okay, but don't make that your central argument. Don't make that your central argument. Okay, I'm an attorney. I'll be in the courtroom, and someone will come up and they'll say that this individual is claiming sovereign citizenship. They're coming into the courthouse, coming up to see the judge. Eyes roll. The judge gets defensive right away, et cetera, et cetera. So it's not always the best card to play. If you're going to use that card, though, what I would say is to mix it in, or just make it a part of your other legal arguments. Okay, and in a way, it can possibly reinforce and strengthen those arguments themselves. Okay, so that's what I have to say about the sovereign citizenship issue. The other thing too is that case back in the 1830s. The law started to change. Even John Marshall went back on one of his decisions, all right, and started to allow some sovereignty to the Native American tribes. Okay, a couple years later, Andrew Jackson practically ignored those decisions and any of the sovereignty that was given to the Native Americans, and he ordered the Cherokees off Cherokee land in Georgia. Okay, that's why we have the Trail of Tears. They were moved to Oklahoma. Thousands of Native Americans died in that forced march. All right, and that just reinforces my point. Right, at the end of the day, this president basically ignored some of the sovereignty that they had gained. And why was he able to do that? Well, he commands the army. He commands the military forces. Okay, he can tell these people what to do and where to go. So it's a sad story. Again, I'm sympathetic to the sovereign citizenship argument. I mean, listen, if I was a multi-billionaire, I'd buy my own island. Okay, there are islands that exist that you can own that are outside the sovereignty of an established nation. But the truth is, in 2019, escaping the grasp of an established nation, for better or worse, is almost impossible. I mean, even if you went out there and you lived in nature, you're not necessarily escaping the grasp of the government. And it's tough. You can't always trust the government. A new government comes into power and may do something different than the prior government did. And that's sort of along the lines of what happened to Native Americans in early American history. So if you want to use the sovereign citizen argument, I would say mix it in with other actual legal arguments, because then it might give you, as long as you're a pro se litigant, a little extra persuasive punch, right? So, you argue your case on certain merits or facts, okay, that pertain to that case or the law that the United States recognizes, and then, throw in there as well, your arguments about the common law and, sovereignty. It may actually help you, and it may be slightly persuasive. I had, let's see, anybody have any questions in here? I see it. Raymond, thanks for coming in. John Smith, the Amish. That's a good question, Yolanda. That's a good question with the Amish. The truth is that the federal government still, the federal and state government still retain jurisdiction over the Amish. There was it was sort of comical. There was a case a couple years ago, when the Amish, sometimes they'll fight amongst each other, and there was a kidnapping, and they took one of the community leaders, kidnapped him, tied him up, and shaved his beard, right, as an act of embarrassment. Those men who did that, who kidnapped the community leader, were prosecuted under state law. I can't remember if this occurred in Pennsylvania. I believe it may have. But those men were prosecuted under state law. They were kidnapping charges, etc., just like non-Amish would be. Now, the Amish actually may have, yeah, you remember that. The Amish may have special rules. I'm sorry, there may be certain laws in the in an individual state, okay, that favor the Amish, but what you're seeing there is not sovereign citizenship. What you're seeing is the federal government giving a certain group special privileges, which is just like they did with the Native Americans over the years. The Native Americans have a degree of sovereignty only because the government grants it to them. It's not the same as saying your laws don't apply to me. Think about as well, let's say diplomats, foreign diplomats from foreign nations, diplomatic immunity. If you ever saw, what was that, Lethal Weapon? But that's a real thing, is people who come to this country on diplomatic missions. Okay, we have a treaty or an agreement with that other country to treat that person in a special way. It's more the United States giving up that jurisdiction rather than never having natural jurisdiction over them. But you're not going to see a case in the United States where they recognize sovereign citizenship. Now, that doesn't, look, I'll add this, an individual judge at a magistrate court, might be sympathetic to it. Who knows? I doubt it. It's going to be a tough sell. So again, I would say steer away from it. And if you are going to use it, then do it, mix it in with good law and good facts. I just, thank you everyone for tuning in. I just wanted to make a quick video on this because I believe, John, that you had brought this up before. I think it's a popular video out. It's a popular issue out there. I'm actually going to read more about it, maybe do some more videos on it in the future. So thank you everyone in my chat for tuning in. John, Raymond, Yolanda, I appreciate it. And absolutely, Yolanda, me and her are going to be doing something on here soon. So tune in on Wednesday. We're going to do a live through, we're going to stream it, webcam. We're going to talk about some issues. My show, I've been focusing on the opiate crisis. I want to bring people in who have experience in dealing with it in one way or another. I think Yolanda has a very unique point of view. So anyone who's watching this, tune into my show on Wednesday night. We're going to go live. Subscribe, hit the share, comment. YouTube loves comments. I appreciate all the love. Thank you, Raymond. And suggestions, draw in the comments. If you want me to talk about certain topics, drop them in the comments. Thank you very much. Good night.